All right, I see people are starting to join, so I'm going to go ahead and get started with the introduction. So my name is Claire Ladd, and I am the Program and Services Manager at the Massachusetts Nonprofit Network. Thanks for joining us today. Just a few housekeeping items before we start. The recording and the slides from today's program will be emailed to you shortly after the webinar, so please keep an eye out for that. And if you have any technical difficulties during the webinar, just let us know via the chat anytime. And you can also submit questions at any time via the Q&A function, and the speakers will address those. I also want to give a little background about us here at MNN. Our three goals at MNN are to strengthen the nonprofit sector through advocacy, public awareness of our sector, and capacity building services. This webinar is part of our webinar series. Please stay tuned for future topics in the coming weeks and reach out to us if you have any topics you'd like to see. Our efforts are made possible by our more than 600 member organizations. To those of you who are members, thank you for your partnership. And if you have not yet joined the network, but would like to take advantage of the networking opportunities, trainings, and cost savings on various professional services, please visit massnonprofitnet.org/join to find out more. All right, for today's webinar, it's keeping tabs on federal grant funds, key considerations, and contracting for services. And it's presented by Eleanor Evans and Rob Leahy, attorneys in the nonprofit group at Hemenway and Barnes, LLP. So I will now hand it over to them.
Great. Well, good afternoon. And we're very glad to be here today. As Claire mentioned, I'm Eleanor Evans, counsel here in the nonprofit practice at Hemenway and Barnes, and I have practiced with nonprofits for over 20 years, including a network of nonprofits that relies significantly on federal grant funds. And I'll let my colleague Rob introduce himself.
My name is Rob Leahy. My background is also in government grants and contracts primarily. I've been doing this work for about 17 years. I most recently was at Northeastern University and just joined Hemenway and Barnes a few months ago.
Great. And we should say that that if it's possible to unmute yourselves, I don't know if it is, but if it is possible, we can explore that because we're expecting a small group today, and we'll be happy to have real-time conversation. And alternatively, if you want to put Q&A in the Q&A function on Zoom, we can answer your questions that way. Feel free to ask them or make comments throughout the webinar. We'll also be having a few questions for you during the webinar. And so, feel free to respond in the Q&A to those questions, and one of which will be a polling question, so you can respond via the poll. So today we're going to be covering various elements of determining what to do when you have federal funds and you're contracting for the use of those funds with others outside of your organization. So first, we're going to look at the applicable legal requirements that apply. Then we're going to talk about also the distinction between federal grants and federal contracts, so that you're sure that you're in the right ballpark here. Then we're going to look, assuming you have a federal grant, we're going to look at the distinction between a subrecipient or a subgrantee versus a contractor or a vendor. And we're also going to look at when you're contracting with individuals to determine whether they are an independent contractor for your organization or actually an employee of your organization. Then we're going to look at dealing with subrecipients and some things to think about there, dealing with contractors, and then at the end we're going to finish up with just a list of some key agreement terms that you'll want to think about in drafting your agreements, whether you're dealing with a subrecipient or a contractor. So actually, we'll just get going with a question or two to just learn a little bit more about you and the types of federal grant funds your organization receives. So our question to you is, what type of federal grant funds do you receive? And do you receive them directly from the federal government or from another organization, such as the state or another nonprofit? And It doesn't look like I have a way to unmute you. So if you're able to unmute yourselves, feel free to do that. And otherwise, if you could just put your responses in the Q&A or the chat function on Zoom. So feel free to, because we're just curious, because if you respond to this question and tell us what kind of funds you receive, we might be able to tailor our presentation a little bit more specifically to the type of funds that you receive. Go ahead.
No, I don't know, Eleanor, if we want to keep moving on.
Yeah, we'll keep going. But if you feel free to jump in, participants, if you have questions throughout, either through the chat or the Q&A.
All right, so as Eleanor mentioned, we're primarily focused on talking about the sub level when it comes to government grants and contracts. But in order to have that conversation, we really need to start at the top insofar as we need to know what the original, what some people refer to as the prime award, whether that constitutes a grant or a contract. That determination is made at the agency level. The federal government makes that determination, and the federal government has rules by which it has to make that determination itself. Once that determination gets made, that decision then flows down from there. But at the agency level, there is a rule called the Federal Grant and Cooperative Agreements Act that dictates whether or not the federal government is issuing a grant in the form of an assistance vehicle or a contract. And this slide here is outlining a little bit of how that determination gets made. And what it boils down to is what is referred to as the principal purpose test. Like I mentioned, whether the principal purpose is to make a grant of assistance for a public purpose, or whether the principal purpose is for the federal government to buy goods or services for its own operations. It sounds like it may be fairly straightforward, as we'll talk about in a little bit. It's not necessarily always that cut and dry.
And so I noticed that we got a response through the chat about, so one of our participants says that their organization is receiving some federal earmark funds through the Environmental Protection Agency, but not sure which grant program, and that they also receive grant funds through the state Environmental Protection Agency. And so one thing I might note here is that there are, so I went on the GSA, the General Services Administration website, and preparing the slides just to look up some examples of contracts, federal contracts. And so there are some, for example, here, I found some of monitoring riparian birds and native fish, or doing water research in national parks. So if you are doing work in the environmental space, it's conceivable that you could get either a grant or a contract from the feds. And there may be other circumstances such as research where that might be the case as well. So the point here is to look at the document that you're getting from the feds to determine, is this a grant or is it a federal procurement contract? And usually if it's a federal procurement contract, there would be some reference to the federal acquisition regulations in there.
Yeah, and you know, we're not obviously focused on that distinction today, but there are substantive differences between the two, and they can be important. So that's something to pay attention to. All right, next slide. So to that point, there are separate sets of requirements that apply both to contracts as well as to grants. And this is a list of the applicable requirements primarily related to grants. The two that I want to highlight that I think are the most relevant for purposes of the folks on the presentation here is first and foremost the agreement, the contract. And then what's listed there in the fourth bullet, the uniform guidance, the regulations that apply to grants. Ideally, those things should overlap substantially because the federal government's obligations is to flow those regulatory requirements down into your contract. So those should be effectively the same. But the first place, as Eleanor mentioned, that you should be looking is in the award agreement that you receive. that should tell you whether it's a grant or a contract. And if it's a grant, what requirements apply. Another point that I think is worth mentioning, simply from the perspective of labels, I think that sometimes people get caught up with the terminology and lose sight of the fact that regardless of whether you call it a grant or a contract, or, I think we're going to be talking about this a little bit later, there are other vehicles. Ultimately, these are just contracts with the government by which you as the entity or the organization are bound by the terms of that agreement. So just because it might be called one thing or another, don't necessarily get distracted by the fact that that is where the requirements and your obligations are found.
And as Rob was saying, one reason that's important to look at the agreement is first to determine, is it a grant or a contract from the federal perspective, but also when looking at that document, it usually will contain references to the other substantive legal requirements that you have to follow. And so sometimes it would be a very long, detailed document, and other times it would be a shorter document that might even be called like a notice of a federal award, that might have cross-references to the uniform guidance, which is a set of rules that talks about basically how to manage federal funds and how they can be spent on what types of things they can be spent on or not. It's general rules that apply to all federal grants. And then, but your award will also get into more specifics about the particulars of, what you're supposed to be doing under the particular award. There are going to be oftentimes a lot of other statutes and rules that are referenced in your funding agreement, that we're not going to get into all the details of those today. But the point is here, when you're entering into agreements with third parties for the use of these funds, you're going to need to think about how to flow down many of these requirements that apply to you as well. And then also, if you're receiving funding through the state, then there are going to be state rules that apply. So I have a citation here on the slide, 808 CMR 1, but then you'll also be signing a contract with the state on the state's standard contract form, but that will also have detailed requirements in there as well.
Yeah, I think that's a great point, Eleanor, because I've had this conversation a number of times where somebody will look at what appears to be a very short document and not realize that the terms, and you might hear this phrase, incorporated by reference, the regulations can be incorporated by reference. So if the award document points back to the regulations and there's language to incorporate those regulations into the agreement, those terms will be read as if they are in the contract themselves. So you could have a 3-page document that is really effectively 100 pages.
And oftentimes the award agreement might also reference your own application to the agency and incorporate that by reference as well. And sometimes they also include things like web links to standard form state documents or federal documents that you need to look at as well.
So to Eleanor's point earlier as well, why does this matter? The really answer is it's because as the prime recipient, you need to know what you need to flow down, and the obligations that the federal government applies to you as the prime recipient organization need to flow down to match the work that's being done at the sub level. And that's what we're going to be talking about more in detail today, the distinctions between a vendor or contractor, and I point out the fact that you'll hear some of these terms interchangeable. Subcontractor, contractor, vendor tend to be on one side, and then subrecipient, subawardee are on the other side. But the bottom line here is that whatever is in that prime award, once the determination is made as to whether or not the sub falls into one category or another, those terms then need to be flowed down commensurate with that relationship.
And the distinction is also important because there's a different selection process used. So you have to follow federal procurement rules that are contained in that document called the uniform guidance that we mentioned. If you're selecting a contractor, AKA vendor, if you're selecting a subrecipient, and usually the key point with procurement is that there has to be competition for that procurement, unless an exception applies. Whereas if you're subgranting, you don't necessarily have to have competition to choose your subrecipient, but you do need to engage in a risk assessment that we'll talk about. And then once you've working with a subrecipient, you need to monitor the subrecipient in a way that you don't have to monitor a vendor, where with the vendor, it's just, did they produce the goods or the services that you're contracting for?
So I think we're going to look at an example as to kind of how this comes into play in practice, which is not necessarily an unheard of situation where you have an organization, CARES Act funds, do good receives CARES Act funds, issues a subaward to full covered food, and then full covered's CFO embezzles $1.5 million, and now the federal government is looking at who's going to make the government whole. Like we mentioned earlier, do good is in privity of agreement with the federal government. They are on the hook for the funds that were received by the federal government. If do good has done what they should have done and properly characterized full covered food pantries award, it would have flowed down the rights and obligations from the prime award down to full covered. So even though the federal government doesn't have recourse directly necessarily against full covered, the terms are still present between do good and full covered for then do good to flow those obligations down to full covered, right? That's where we get that kind of term flow down.
And so basically what would happen here is the government funding source would come knocking on do good's door and say, we would like our money back, please. And do good would have to pay it back regardless of whether it can recoup from full covered. But as we'll talk about later when we get into the contract terms, do good should have a contract with full covered that obligates full covered to pay do good for any funds improperly spent. And another thing is that you'd want to have in the agreement with full covered, you'd want to have an insurance provision to make sure that they have insurance to cover things like embezzlement, so that, because, you know, if you don't have that, they're likely not going to have those funds sitting around since they were stolen from their organization.
So this is a comparison chart. There are many available out there on the web if you Google to find them. This one I particularly like because it's right out of the regulation. And as you'll see here, the distinctions really boil down to whether or not there's a substantive contribution on the part of the sub. The subrecipient looks and feels a lot like the prime awardee insofar as they're involved in the project. You see there in the third bullet, performance is measured according to the federal program objectives. There is responsibility for programmatic decision making. All of those things tie directly into the substance of the awarded project, whereas the contractor is generally going to be selling services on the commercial marketplace, no different than it sells to anyone who purchases those services. You know, there's a lot behind why the monitoring aligns with these two distinctions and why there's competition requirements. As Eleanor pointed out, if you're a subrecipient and the competition requirements are not the same as they are in the vendor context, it's because you're kind of looking at their contribution all along the way and in light of the scope of work and in the project. Whereas the contractor is on contract to provide a discrete service, and you need to know that that entity is best positioned to provide those services at a competitive price. So this topic I find particularly interesting because there is certainly subjective analysis that goes into these determinations. It's not necessarily cut and dry, and there will be scenarios in which you may have experienced them already, in which a sub and the prime do not agree on the type of relationship, and this can sometimes be flexible in terms of achieving the ultimate intended goal with respect to the relationship. But ultimately, it's up to the prime awardee or the pass-through entity to use its judgment and classify the award. If it is questionable, there is opportunity to engage the federal awarding agency and in part of that discussion. But like we mentioned earlier, the agreement is with the prime awardee and the federal government. So the ultimate determination is going to fall to the prime awardee if something goes wrong, and if the prime awardee has to answer to the federal government, the prime awardee, the recipient, is only going to be left with what is in the contract between it and the subrecipient or the vendor.
And also sometimes you'll see in our presentation that we refer to the prime recipient or any entity that's receiving federal funds and then passing them through to a subrecipient as a pass-through entity. So we use that term throughout. So it sounds like one organization may or may not have received federal funds yet. So I don't know if you folks on the webinar will have an answer to this question, but if you do, if you could just respond to the poll. What, with your federal funds, do you enter into or plan to enter into subgrants, contracts, or both? Okay, so we're seeing that the one response that we got, you're planning to enter into contracts, which is helpful for us to know because we'll spend a little bit more time on that in the presentation. But we'll also touch on sub awards just because you may encounter those in the future. So I just wanted to go through this scenario to help discuss how subrecipient versus contractor determinations. So our nonprofit Do Good receives a grant from the Department of Labor to provide job training to unemployed workers. They plan to partner with Tech Talk, a nonprofit that offers video production courses to the public. After conducting a preliminary screening of people who express interest in its courses, Tech Talk will refer those who might be eligible for Do Good's DOL job training program. And they'll be referred to Do Good, and then Do Good will determine whether they're actually eligible to participate. And if they are, then Do Good will pay a fee, Tech Talk a fee per its usual fee per participant per course. And Do Good's also going to work with other training providers, both nonprofit and for-profit. And those providers are going to be subject to some DOL program requirements about non-discrimination and privacy of participant information. And all of the training providers, including Tech Talk, will provide regular status updates to Do Good on the program participants' progress. And so maybe I'll throw this open to Rob and have him be our guinea pig here to answer this question. So Rob, what do you think here? Is Tech Talk a subrecipient or a contractor?
Oh, sorry about that.
That's okay.
Yeah, well, I think that you know, this is a good example of where you can have that discussion. I think that they're a contractor here, but if, you know, this question does come up occasionally where a contractor wants to have a more substantive role, and you could imagine a scenario in which the scope of work could be adjusted if they had the right kind of people to participate as a sub-awardee.
Right. And so this was a real situation that I dealt with. And I determined that the training providers here were contractors. However, the Department of Labor program person, well, first of all, we reached out to the Department of Labor before entering into the agreements to say, hey, we're thinking about this, do you have any thoughts? Because sometimes funding sources will have some guidance that they are willing to provide. But in this case, they said, no, we're not willing to provide guidance. You have to use your own judgment. But if you're wrong, we'll come in and make you change things later. But, and so what I did was working with the client, we recorded the factors of why we determined these folks to be contractors. And, the main thing is that they're paying, they provide these service to other people. Their do good is paying their usual fee per participant. Now, maybe there are some differences here in that, the funding terms required these non-discrimination and privacy requirements to apply to all people that the grantee contracted with. So, that's really not determinative one way or the other. And then maybe the thing that's might be a little different is that these training providers have to provide status updates to do good on the program participants' progress. And maybe they're also referring them to do good for eligibility screening, but they're not doing the eligibility screening themselves. In this case, the organization started out working only with nonprofit training providers. And when the DOL came in to do their monitoring, they just looked at one of those providers, which itself gets a lot of federal grants. And so the relationship looked to the DOL at that time more like a subgrant. But if they had talked to some of the grantee ended up working with some for-profit training providers, and if they had monitored those folks, they might have determined that it was the opposite. So here, all we had to do was change the contract with the nonprofit. It didn't end up having a substantive difference, but in some cases it could have a difference. And so, for example, if you said that an entity was a grantee when the funding source thinks they're a contractor, then they'd say, well, you didn't procure this through competitive means. So anyway, but it's something to be aware of and to be thinking about, and try to just document your reasons for why you picked one or the other. So I'm going to turn to looking at the issue of independent contractors versus employees. This is a situation where your organization is engaging an individual to provide services for under your federal grant program. And so then the question is this person really a contractor, or should they be deemed and put on the payroll of your organization as an employee? And the reason it matters is because independent contractors don't get a lot of the legal protections and benefits that employees get, including things like Social Security and unemployment, and as we indicated here, workers' compensation. And then the state loses and federal governments lose tax and revenue in those areas as well. And then there can be significant legal liability if an employer mischaracterizes an individual as an independent contractor when they really should be treated as an employee, and that the employees or the individual can bring a claim as well as government agencies. There can be a whole, we could do a whole webinar on this topic. So I'm just mentioning it to flag it for you when you're thinking about contracting with others with federal funds or otherwise. But we could go into much more detail about it. The other thing that's complicated about independent contractor versus employee is that there are different government agencies that use slightly different definitions. So there are IRS factors for tax purposes that look at things like, does the organization have the right to direct and control the person doing the work and the work that's being done? And they look at things like, how much instruction is the person given? Are they given training? How are they evaluated, if at all? Does the organization have the right to direct or control the financial or business aspects of the job? So, for example, if the individual is just perform services for a lot of people, that's the ability to seek out other business opportunities listed here on the slide. If they're not being reimbursed for business expenses connected with the work, that's also an indication that there might be an independent contractor. How are they paid? Are they paid a flat fee versus a regular wage amount? That can be a factor, but it's not determinative. And then how do the parties perceive their interaction with each other? Again, though, what you state in your contract, if you just state, oh, you're an independent contractor, does not make that person an independent contractor under the law. It's the government agencies and courts look at the totality of the relationship. There are also factors under the Fair the Federal Fair Labor Standards Act, that I'm not really going to go into, but that determine if somebody is an employee or an independent contractor for purposes of minimum wage and overtime laws. And these are factors that courts have developed, including the Supreme Court. The Department of Labor has been going back and forth in the Trump and Biden administrations about regulations in this area, but just suffice it to say, they have their own definitions, which are kind of similar to the IRS one. But since we're based in Massachusetts, we also have a Massachusetts definition, which is stricter than either of those federal definitions that I mentioned. So under Mass law and the laws of some other states, to be classified as an independent contractor, the worker has to be free from the employer's direction and control. So that was a factor in the federal ones. The services that the worker provides must be outside the employer's usual course or place of business. And that one that's the trickiest one to meet. And the worker must be customarily engaged in an independently established trade, occupation, profession, or business of the same nature as involved in the services performed. So in other words, they are performing similar services for other clients as well as your organization. And so I'm going to just move on here to a example. So in this case, Do Good has a Head Start program to provide early childhood education to children from families that are low income. They plan to engage Holly Hartfelt as a part-time mental health consultant to provide mental health services to children in that program. So Holly meets weekly with the Head Start program director about the status of her projects and her work with the children. When she's not working for Do Good, she provides services to other early childhood programs. So I guess, Rob, I'll call on you again. Do you think that Holly is an employee or an independent contractor here?
Independent contractor.
Yeah, I would say she's an independent contractor. I mean, she's getting some direction and control, and presumably, she has to comply with Head Start regulations and that sort of thing. But here, she's first of all, she provides services to other early childhood programs. It might be different if the organization itself, was a mental health organization and had other mental health people on staff. But if they're contracting out for all their mental health services, then that's not a, you could say that that's a service that's outside the usual course or their business, even though it's might be considered integral to their Head Start program. And so anyway, I would agree that he or she is an independent contractor, but it can get, again, like the subcontractor, subrecipient contractor distinction, independent contractor employee distinction can be a little tricky sometimes. So dealing with subrecipients, there are specific rules in the uniform guidance about what the pass-through entity or the prime funding source, the prime grantee is supposed to do. So first of all, as we talked about, you're supposed to determine whether they are a contractor or a subrecipient. Then you need to have an agreement with them that includes certain specified information and that designates it as a subaward agreement if you've determined that they are a subrecipient. You have to conduct a risk assessment before contracting with them to determine how much monitoring or other types of subaward conditions you want to apply to them to make sure that they're using the federal funds appropriately. Then you're supposed to monitor their activities to make sure that the funds are being used for their authorized purposes and that the subrecipient is complying with all the various regulations and rules that you as the grantee have to comply with. And then, of course, you also want to make sure that they're meeting their performance goals. So like, say, in the Do Good DOL program, if they had a subrecipient that was, say, serving people in a particular geographic area, and they are actually a subrecipient, they're screening the people and they're running the program in that one particular geographic area, you would have goals in there about like how many of those people got placed in jobs, for example. There's some other requirements here where you have to make sure that if the subrecipient expends over $750,000 in federal funds in a fiscal year, that they have a so-called single audit. And then if a subrecipient is not if you find out that they're not using funds for authorized purposes, or they're not meeting their performance goals, or they're otherwise out of compliance, you need to consider enforcement actions against them. And so you want to understand what rules apply to you as the organization, and then pass those rules through to your subrecipients. You're going to select your recipients using a risk assessment to determine how well are they set up to use and monitor these federal funds. You might, in doing that, depending on what the relationship is going to look like, you might want to have, you may be giving them X amount of money to do this program. And so you want to have a budget with them that they're required to follow. And then they also, under the uniform guidance, you're required to cover their indirect costs through your federal funds that you're subgranting. And then, so we talked about the subaward agreement, which we'll get into more detail later, but while you're managing the subaward, you're going to be getting reporting from the subrecipient in terms of programmatically, how many people are in the training program, for example, how many people, what progress are they making, what's their job placement rate. And then you'll also be getting financial reports from the subrecipient in terms of how have you spent your funds to date? How does that compare with the budget? Are you providing documentation of how those funds were spent? And then you would want to periodically monitor them, and the degree of monitoring that you engage in will depend on the amount of funds involved and the type of services that are being provided. And if they need help, you would provide technical assistance to them to help them understand how to meet their requirements. And then at the end of the award, you need to just close it out and make sure that you've gotten all the reports necessary and have accounted for all the federal funds. As I mentioned before, when selecting subrecipients, you don't have to use a competitive process. In some cases, people list who their subrecipients are going to be in their application when they're applying for the funds, but just because you list somebody there doesn't mean that they're either a subrecipient or a subcontractor. So you need to go through that analysis. And then if they are a subrecipient, sometimes the funding source will say, if you included them in your application, we're approving that. Our approval of your application means we're approving them. But in other cases, sometimes you might have to get funding source approval in order to enter into a subrecipient relationship. So you just need to be aware of that and in contact with your funding source about that. You can choose to use an application if you want to, and you may want to use a competitive process. It depends. And then you want to select them based on criteria related to how well are they going to be likely to perform under this award, and how are they going to be able to manage the federal grant funds, and what systems that they have in place. I mentioned a risk assessment. So as part of that, you want to look at factors like what's their prior experience with similar awards. Have they had audits in the past, and what have those results been? Do they have, how experienced are their people who will be your key contact people under the award? And if they have gotten federal awards, how have they had any monitoring findings under those awards? If you find that, say, they are inexperienced or they don't have a lot of systems in place, there may be certain types of conditions you'd want to put into place in terms of paying them on a reimbursement basis, or having them proceed only to a certain point and then get approval from you, or requiring more detailed financial reports or more frequent monitoring, for example. Okay, I think so I kind of just talked about why you would want to do a pre-award risk assessment. But the main reason is that, as Rob discussed at the beginning, your organization is getting their federal funds. You're responsible for every penny of those federal funds. And so to the federal government or to the state government or other pass-through entity that you're getting them from. And so when you're going to be handing out those federal funds, you want to make sure that the entity that you're handing them out to is able to manage them and to in an appropriate way. And so that's why you want to conduct a pre-award risk assessment is to make sure that they can do that, or that you have systems in place if they're not particularly experienced, to make sure that the use of federal funds is appropriate and in compliance with the law. This is getting kind of technical, because especially if you're not planning to do federal subgrants, but I just want to touch on it anyway. Under federal grant law, there's this concept of indirect costs, which is to help the grantees and subgrantees cover their administrative costs. And there are different ways that these are calculated or determined. So in some cases, some organizations negotiate what's called a federally negotiated indirect cost rate with a federal agency. And so if somebody that you're subgranting funds to has one of those, you have to honor that if they intend to charge indirect costs to this subaward. If they don't have a rate, you work with them to determine what an appropriate rate would be. You can negotiate an indirect cost rate in various ways, or you can use what's called the de minimis indirect cost rate, which is 10% of certain costs associated with the subgrant. So anyway, you don't need to know the details about this really, but just to know that first of all, if you're getting federal funds yourself directly from the federal government, or if you're getting them through a pass-through entity, you should be aware that you, as a recipient of federal funds, are entitled to have your indirect costs covered for the most part. So you want to be asking about that, and probably if you're applying directly for federal funds, you would have information about that in your application. But so be aware that you're entitled to that, and sometimes if you're both if you're getting them from the federal government or from a pass-through entity, sometimes that takes a little negotiating with them or discussion with them back and forth to make sure that your indirect costs are covered. So that's one thing to be aware of. And then the other thing is that if you're passing through federal funds, that you need to do the same with your subrecipients. Also, the uniform guidance was amended in, I believe it was 2020, and gave a little more clarity about using a type of thing called cost allocation to account for indirect costs, which is a welcome change. Okay, I think, well, maybe I'll call in Rob again here. So Do Good, in this case, they want to subgrant HUD funds to another local nonprofit, which doesn't have a federally negotiated indirect cost rate. So what options do they have here?
So, I mean, I guess technically you could do any of these things. But well, with the exception of do not allow indirect costs.
That's right.
Obviously, in Eleanor, to your point, I think that one thing that we should point out is that, these are for cost reimbursement agreements. That will be the vast majority of the grant awards that an entity receives. That might be less true in the contracts context, but either way, it's just a recognition that, of course, if you're going to be recovering your direct costs, there's also indirect costs associated with those direct costs. And if you don't recover those, you're operating at a loss. So, theoretically, you could have situations, and you do have situations where an entity will under recover its costs for any number of reasons. But that's certainly not an ideal situation.
Right. And that's the thing. I mean, so in this case, Do Good cannot go to Helping Hands and say, here's your award. No, we're not putting anything in for indirect costs. Do Good can't do that. But Helping Hands could say, you know what? There's not a lot of money under this subaward. And so we have funds from other sources to cover our indirect costs here. So we're going to choose to devote all these funds to direct cost of, running the program. But you, as a pass-through entity, cannot require that. And just as your funding sources cannot require that of you, your federal funding sources and state passing through federal funds. Okay, so I'm going to kind of skip over this monitoring piece just because it seems like folks may we want to get to the contracting piece, but there are, different kinds of reports, as I mentioned, financial and program, that you'd want to get from your subrecipients, and then these are different areas where you might want to be monitoring subrecipients if you get into that. And again, the monitoring will depend on the size and scope of the award, and there are different ways you can monitor, which could be just having them send you information, or you could be going there to their offices. But basically, you want to document your monitoring activities so that in case your funding sources come in and ask you, did you monitor, you can show that you did. And if there are problems, you want to work with a subrecipient to fix them.
All right, so we're talking about contractors now. And Eleanor touched on this a little bit earlier. The next slide talks about the procurement process for selected contractors. So here, we have the flip side of that coin. If you have the subrecipients on board and you have contractor activity or vendor activity that needs to be added to the project, there's not going to be a subaward or a subrecipient relationship. This is going to be, a traditional contract for some kind of services. It could be anything that's commercially available. These rules were implemented relatively recently. I don't know, Eleanor, if you know exactly what year. I don't remember.
So it used to be, so the uniform guidance, there's been a set of rules that determined how federal funds could be spent and systems you had to have in place for a long time. But those rules there was a full overhaul of them in the maybe 2015, 2016.
Yeah, that's what I was going to say.
Oh, go ahead.
No, it's been relatively recently.
And so prior to that, the rules that applied to nonprofits were pretty loosey-goosey around procurement, whereas the rules that applied to state and local governments were more stringent, and the rules that are in the uniform guidance are based on what had been previously the state and local government rules. And they've gotten more strict in some areas. And
yeah.
Just one thing to think about is that, so back to our Holly Hartfelt example. So in that case, we determined that she was a contractor. We talked about she's being an independent contractor, but I would also say that she would be a contractor as opposed to a subrecipient. And so therefore you would need to engage in a procurement process where you're depending on the size of the procurement, if it's over a certain so-called micro purchase threshold, you'll have to have some level of competition. And so this is what you would be having to engage in when procuring the services of a mental health consultant in Holly's case, or other types of services and goods.
Yeah, and one thing that you'll see as well is that these rules and this set of rules and the other rules that we're going to talk about in a minute mirror what's in the federal acquisition regulation. So these are concepts that are also drawn from the federal acquisition procurement contract context. And a lot of the terminology and the concepts are the same. You'll see here, right, we're talking about this distinction between contractor competition and procurement as compared to subrecipient selection and monitoring, which makes sense because you can imagine a situation in which there may be a subrecipient that is an individual that works at an institution or an entity, and they're uniquely situated to perform that one function that is substantively tied to the project. There may not be the ability to compete that, and that person's an expert in that field, and you need that particular entity and that person to work on the project. Whereas that tends not to be the case. There are exceptions, which we're going to talk about in a second, but that's generally not the case for contractors, and that's why there's a full and up competition requirement. This is a set of factors that needs to be checked before retaining the services of a vendor or contractor. I would argue that probably the most important one is the contractor integrity element. As a threshold matter, you may be prohibited from engaging a contractor or a vendor that has a contractor integrity problem, particularly suspension and debarment. But even beyond that, it just makes logical sense. If they have an integrity problem, they're probably not going to be a very good participant, vendor, contractor on your contract.
And also to note here that it says award contracts only to responsible contractors with the ability to perform successfully. So it doesn't always mean that you have to go with the lowest bidder. You want to be looking at, if you're talking about anyway, so just keep that in mind, that the responsibility and their ability to perform successfully is the most important thing here.
Yeah, there's not a requirement that you go with the lowest price that's acceptable. You know, it can be a balancing.
I mean, if it's
Here-
a sealed bid thing, we'll talk about but it still talks about lowest responsive and responsible bidder.
Yeah, and this is the sliding scale that you would expect to see that's commensurate with the amount of money that's being spent. And there are different processes by which you can, and maybe I guess the way to say this is that these are the thresholds by which you must meet certain criteria. I guess theoretically, Eleanor, right, you could have a situation where you have a below the micro purchase threshold contract that you want to use competitive proposals for. You know, you can certainly do that, right?
Sure. I mean, and one thing to note here, so these thresholds here are what's in the uniform guidance, and but if your organization, depending on its size, may have lower thresholds in your own procurement policy. So if that's the case, then you have to go with the lower threshold. And then, as Rob said, there could be other circumstances where you decide for whatever reason, even if it's below your threshold, that you want to compete it.
You know, and these are rules that are aimed at ensuring that you're being, you know, good stewards of federal funds and getting responsible contractors. And so, like I said, in the procurement contract context, you're going to see a similar structure for the federal government itself to what you're seeing here, right? These levels at which different competitive requirements, sets of requirements and thresholds must be met before procurement can take place. So, back to the point we were making a second ago, being that there are exceptions, again, you see this reflected in the procurement contract framework, where you can sole source award to a particular vendor or a contractor for various reasons, whether or not it's because that, you know, it's under a certain dollar amount, there's an emergency or exigency, which tends to be not very common. There's an authorization. The most frequent, at least in my experience, I don't know, Eleanor, if you have a different experience, is that it's only available from a single source, right? So even on the contractor vendor side, we kind of see a similar dynamic taking place. You know, there's a million examples you can come up with, but a lot of times it may be a vendor that provides a product, and it's an innovative product, and it's the only one that performs that function or performs a function at that level and that quality that you need for your project. And then you need to justify and explain as to why you're going with that one sole source.
Right. So the key thing is, if you're doing sole source procurement, you need to document why and how your procurement falls under one of these exceptions. And available only from a single source doesn't mean, oh, well, we've worked with this person in the past and we like them. You know, you have to show that in some whatever way that it is only truly available from that source. I did see some public exigency or emergency situations during COVID, when people, you know, maybe they had some kind of procurement and they didn't, especially at the beginning of COVID, when people were transitioning, you know, had to get stuff done and couldn't come into the office to do it. But that tends to be more like, you know, disasters and pandemics and things like that. One of these bullet points is that the funding source, whether it's the federal awarding agency or the pass-through entity, expressly authorizes it in response to a written request. So that is one way that you can do that.
So in terms of, you know, selecting contractors, a lot of this might just kind of simply be common sense, or you would hope that the solicitations have to be clear as to what's being required. It's a description of the technical requirements and what you're buying, right? These are things that go into a contract anyway. You know, to Eleanor's point a second ago, there's a distinction in this sometimes comes up, a distinction between the technical requirements and the brand name specification. So a sole source requirement, drilling down on the requirements and capabilities of a particular item, is not the same as simply saying that you want X brand. X brand has to be uniquely situated in terms of performance capabilities, as compared to any other brand that's out there. If that's the case, it's the technical requirements themselves that are going to drive the sole source exception effectively. And like Eleanor said a second ago, what this comes down to is whatever decision is made, and this probably goes for a lot of things with contracting with the federal government, just document that determination. You know, if it turns out that somebody disagrees with that determination, it's better to have it documented rather than make the determination and then somebody disagrees with it and you have no way to back it up as to why you made that decision that is different from an auditor or somebody from the government, program manager, etc.
So let's see. So, and we're talking about Do Good again. And so they've worked with a training consultant in the past and they think highly of their work and they want to hire them to create an online training program for participants in that job training program we talked about. And so Do Good CFO calls the Department of Labor program officer and describes what they're thinking of doing. And the program officer says, sounds good. So Rob, can Do Good go ahead and hire the consultant?
Well, no. This comes down to the documentation discussion we were having a second ago. You know, as long as the person has authority and it is documented, then it's going to be acceptable. But those are the two key elements.
Okay. And then in our last few minutes, we are going to talk about key agreement terms, but don't worry, we're not going to go through all of these in detail, just say a few words. So there's some terms that you're going to want to have in your subawards and your contracts that talk about like the length of the contract and what the services are, how much you're going to pay. Often you want to phrase that in a not to exceed way. And then certain other things, insurance, as we mentioned, complying with applicable laws, intellectual property rights, how you're going to terminate the agreement, any kind of confidentiality rules and the like. Then there are key agreement terms that are required by the uniform guidance and for different types and different circumstances. So we have those listed here on this slide. And we mentioned about suspension and debarment before. And as Rob said, there are certain people that you can't contract with under federal awards if they've been so-called suspended or debarred from getting federal funds. And so there's a website, sam.gov, that you can check for that to look them up. And then there are certain subaward terms, the terms that you have to include in subaward agreements, but not contracts. And so they're listed here on this slide. And I like to put them in as just a schedule at the end. And then other pieces that you would want to include to talk about the programmatic and financial reporting, monitoring and evaluation, having access to their records and financial statements by you and your auditors, saying that they're responsible for costs that are disallowed or misspent is very important, and things around record retention and access, for example. So I've given a couple additional resources of places you can look for more information about this. My former organization, CapLaw, has some resources around pre-award risk assessment, a sample subaward agreement, which is on the more detailed side of subaward agreements, as well as a sample procurement policy. And then there's also an organization called the Federal Demonstration Project that works with federal grantees, especially universities, and they have some subaward forms available on their website as well. So thank you very much for joining us today. And if you have questions after this webinar that come up, feel free to contact us. We would be happy to answer them.
Thank you again to Eleanor and Rob for your great presentation today. And thank you all and have a great rest of your day.
Thank you.
Thank you.
Bye.